what happens in just the mechanic, just to illustrate the point, is you still get charged in New York with the federal gun crime, if you're not in lawful possession of it, and then you get to assert the federal safe passage provision as a defense, and that defense is going to trump state law, and so theoretically, this person should be acquitted, assuming they meet all these qualifications. We are the Armed Attorneys. Today we're talking about Second Amendment sanctuaries. There's some developments in this area of the law, especially when it comes to the state of Missouri. They're taking a second bite at the apple. This is why I love, our little states are the laboratories of democracy. I don't know who said it, but it's a quote out there. They're, I think, perfecting their Second Amendment sanctuary bill, and there's something for everybody to learn here. Maybe you get this in your state, but before we begin, show your support for the Second Amendment by hitting that like button. And Leslie Cross, great to see you again.
Yeah, thanks for having me.
Covering for Emily for a couple episodes. Emily, very busy, busy time of the year, lots of court things, lots of things happening in Austin, and we appreciate you having you here. But today we're talking about, and maybe you folks remember, but back in 2021, the state of Missouri passed a very aggressive Second Amendment sanctuary bill.
Yes, they did. They were saying that the whole bunch of things were nullified, and they went into very specifics on which laws they would not help enforce, which federal laws they would not help enforce, line by line, essentially.
Yeah, and, all right, great. Obviously, don't want to be helping the feds enforce unconstitutional infringements to the Second Amendment. But, the United States government sued Missouri saying, hey, guess what? A couple of things. First, supremacy. The federal government is supreme. It is the supreme law of the land. We are occupying the area, the field in some of these topics. And so for that reason, because of supremacy, this law is no good. And I think it's worth talking about supremacy just a little bit because we get this question a lot.
We do. So there's a lot of people, especially in Texas, and I've heard of other states doing it as well, pass some laws that kind of try to override the federal law. One, for example, is our Made in Texas suppressor bill that was passed a couple legislative sessions ago. And I have people call and ask me all the time and say, okay, well, if I get the parts in Texas, the parts never leave Texas, I make the suppressor in Texas, I follow all the rules, I'm good to go, right? Wrong. The answer is wrong. You will be going straight to Club Fed. You will not pass go. You will not collect $200. The federal government doesn't care that Texas passed a law saying that you can have this. The federal government is the one who monitors and keeps track of suppressors. They make suppressors legal or not legal. So Texas can't come in and say, hey, you know what, feds? It's cool. We're going to have this bill. We're going to say that we're good to go, because it just doesn't work that way.
Yeah, and the logistics of that bill is a little hairy to begin with. And other states have tried this, and we really thought we had it down, and we're going to kind of act on this because we'd had cases all over the country that had been litigated. We kind of spotted all the holes. We tried to fill the holes and make a good go at it, but essentially it was going to give people the ability to say, all right, I want to make one of these suppressors. I'm going to notify the Attorney General. They're going to sue on my behalf, essentially trying to invalidate the National Firearms Act. Essentially, that got struck down in the district court, even with a gun-friendly judge saying, hey, look, you just can't legislate standing here. There's other avenues to accomplish this stuff. It probably was a failing in how these declarations were drafted. We can have a whole discussion about that another time. But, ultimately, at the end of the day, the federal government and the states, they operate independent of each other. They have overlapping jurisdictions. A state can decline to not help, but ultimately, at the end of the day, the federal government is standing right there.
Yeah.
It's in the house with you.
Right. Yeah, exactly. The supremacy is always going to win. The feds are always going to win. And, that's also why the safe passage...
At least in the courts. And they say, we're going to win because the law says we win.
100%. Yeah. Right. Yeah. And it's the same with the safe passage provision, right? So we have the safe passage provision that says that, if you start in a state where you lawfully can possess a firearm, you can travel through a gun-unfriendly state to another state where you lawfully can possess a firearm. So, New York, for example, has such strict firearms laws. They don't allow anyone to have guns in New York. And the reason that the feds can come in and say, hey, you know what, New York, we're going to have the safe passage provision. We're going to say that people can actually go through your state, even though you have state law saying they can't, is because of the Supremacy Clause, because the feds, they override it.
Yeah. And, that's assuming traveling, unloaded, locked, all these other, there's other qualifications to it. But, what happens in just the mechanic, just to illustrate the point, is you still get charged in New York with the federal gun crime, if you're not in lawful possession of it. And then you get to assert the federal safe passage provision as a defense, And that defense is going to trump state law. And so theoretically, this person should be acquitted, assuming they meet all these qualifications. But that equation doesn't work the other way around. In Missouri, they said, hey, all your laws are unconstitutional, they're unenforceable, they're null and void. And the court basically struck all that stuff down. Well, that was HB 85. That was in 2021. And so if you wanted to check out that case saying, hey, this is, Missouri's attempt to legislate the Second Amendment sanctuary issue is invalidated. If you want to check it out, it was in the 8th Circuit Court of Appeals, 231457. Now, the other thing that they tried to do, again, you learn, you put out some test balloons, see what works, see what doesn't, is they added some severability clauses to this saying, hey, guess what? If a court finds any provisions of this unconstitutional, those are severed and the rest of the law is there. The court in this case said, we're not going to play that game. This stuff is too intertwined. You can't sever it. So the whole thing is going down. And then there was some kind of intertwine there with, hey, there may be reasonable and lawful exceptions to the Missouri law. We can talk about that, but like military things like that. They said, hey, all these things too convoluted. The law's going down. Now, the state of Missouri is taking a second crack at it. We're going to call it the Second Amendment Protection Act 2.0. And if you wanted to check this out, this is HB 1175, and it is much more narrow.
Yeah, it is much more narrow. So essentially what they did is they took out that list of actual laws that they said they wouldn't enforce. And basically they said that they would not enforce any federal laws having to do with firearms, firearms accessories, or ammunition.
Yeah, so more broad.
Right. Yeah, exactly. So basically they just said, instead of having this whole list and naming each actual law that we're not going to enforce, we're just going to say we're not going to enforce any federal firearms laws, any federal and firearms accessory laws, or any federal firearms ammunition laws.
Yeah, and apart from, and something different in this kind of 2.0 version, they're not declaring these things null and unconstitutional. They're saying state actors are not going to assist in the enforcement. So this kind of null and unconstitutional, well, that kind of language gets me fired up all day. It really was a detriment to them in the courts because, obviously you had that supremacy issue. Not including that language, I think, second go around, I imagine the United States government is still going to sue over this stuff, but they've kind of limited it. We're not declaring all this stuff null and void. We're just saying, hey, we're not going to assist with it. And it still keeps in some very, very harsh penalties for state officials who aid the federal government in kind of gun control or Second Amendment infringement. So I still think the purpose is accomplished without all the, red meat, rah, let's go do this. But, I think they're have a better chance of accomplishing their goal.
I think so too. I think they're doing a much better job, and they give the courts less to rip them apart on, actually.
Yeah, it's kind of like a shapeless animal thing, instead of saying like, here's our 10 bullet point list of things that are null and void, just saying all this stuff. Well, okay, you got to almost evaluate this stuff on a case-by-case basis based on state actors not assisting federal government. And so when would the federal government have standing to challenge this stuff? I guess whenever the lack of enforcement takes place. I mean, we'll see. But I think that they would have a better chance staving off, kind of this statute being declared unconstitutional.
Yeah, I agree.
Yeah, and I think there's a lesson in here where, all right, we have to identify what the goal is. Obviously, not assisting federal authorities in Second Amendment infringements, goal identified. What is the best way to accomplish that goal? Burning the house down with all these declarations about, the right of the people and all these other things. I mean, fantastic. Love it. Love to see it in the comments section. But you've experienced this. I mean, do you burn the house down in filings with courts?
Typically, no. It depends on the case by case basis, but a lot of times you're trying to get to the point, get to where you're trying to go. And so sometimes all those filings, they kind of get in the way of what the end goal ultimately is.
Yeah, it's the same thing with, clients will be like, oh, I want you to fight every single step of the way. Well, guess what? We have these 10 frivolous fights when we have the real fight.
Right.
The court's not going to, I've lost all credibility at this point. So at the end of the day, it's all about result oriented, how are we going to craft these things? And I think Missouri's doing a really good job. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And always leave your questions in the comment section down below. Until next time, we're the Armed Attorneys.